Hello, class. Welcome back. This is Professor Watson. This is Contracts 1351. Um, we're on week 5, right? Week 5, chapter 4. We're talking about invalid assent. This is our second lecture on invalid assent. So if you haven't watched the first one yet, please do that because this may not make a lot of sense. This week, we are talking about the ways to invalidate assent. So you thought you had an agreement. Everybody appeared to be agreeing on the same thing. But for some reason, it's not fair, right? For some reason, somebody thinks that even though we reached an agreement, we've got a problem and we need to try to undo this contract. And we talked about, we gave a list. We haven't talked about all of them yet, but we talked about 6 ways to try to invalidate assent. We talked about fraud, right? That's that intentional misrepresentation of a material fact that the innocent party relied on, or justifiably relied on, to their detriment. Right? So it requires a misstatement, an untrue statement of material fact with the intent to deceive that the innocent party relied on, that reliance was justified, and to their detriment. All right, 6 elements of fraud. We learned that if you can prove those 6 elements of fraud, then you can seek to invalidate the contract, or you can sue to enforce the contract and sue for damages, or, and this is the big thing with fraud, you can sue for punitive damages, those damages that punish somebody, right? All those other damages just make you whole. They just get you back to where you would have been. Those punitive damages, those are the ones that make you and your trial lawyer rich, right? That's what we all want. We want those punitive damages. We want that $75 million punitive damages award against Donald Trump, right? So we'll all be rich. Fraud is hard to prove, though, because you have to prove that intent to deceive, and you have to prove that it occurred at the time the statement was made, right? So you have to prove that they knew it was false, or they should have known it was false, and they intended to deceive you when they made the mistake, when they made the statement. Excuse me. If you can't, I'm sorry. Excuse me. If you can't prove an intent to deceive, does that mean you're shot? No. Then you may be able to check down to that second one, to that misrepresentation, right? And misrepresentation, you can also use to try to invalidate a contract, to try to undo a contract and go back to square one. Or you may be able to sue under misstatement to enforce the contract as if the statement had been true, right? And so you can be made whole. You can get back to where you would have been or you should have been, right? But you don't get the punitive damages. You don't have to prove the intent to deceive. For misrepresentation, you still have to prove a misstatement of material fact that the innocent party relied on justifiably, that the reliance was justifiable, and to their detriment, that they changed position, they had some kind of injury because of it. But that's only 5 elements. You don't have to prove that 6th element, that intent to deceive. Makes it easier to prove, but it also means you don't have that claim for punitive damages. All right. The third one we talked about was a mutual mistake. Not a mistake, but a mutual mistake. Both parties, when they were negotiating, when they were entering into the contract, both parties made the same mistake about the same fact, right? The same material fact, and that it was a fact about the subject matter of the contract, right? Not just the consequences of the contract, but the subject matter of the contract. We thought this was more property. We thought this was zoned commercial, those kind of things. Not, well, we thought the legislature was going to make the sale of marijuana illegal, and they didn't, right? That's not a mutual mistake about the contract. That's a mutual mistake about the effect of the contract down the road. But if both parties make a mutual mistake about the same fact about the contract, that may be sufficient to undo the contract. And then we were talking about the 4th method to invalidate a contract or invalidate assent, and that was duress. Remember, duress was we talked about duress as a wrongful threat, right? A threat of wrongful conduct to force somebody to do something involuntarily, to do something against their will. And so we talked about things that are illegal. If you threaten something illegal in order to get somebody to sign a contract, and that forces them to sign the contract, that's almost always duress, right? I mean, if you've threatened physical violence or physical harm, you threaten to burn their house down, right? Those kind of physical things, almost always duress. That's almost always sufficient to invalidate a contract. but the threat doesn't have to be something illegal in order to be duress, right? It can be something that's just wrongful. And there, you're getting into kind of a gray area. You have to determine whether something is wrongful, even if it's not illegal. Is it wrongful, or does somebody have a legitimate interest in doing it? And I wouldn't test you on this because this is peeling the onion pretty thin. This is where easily two parties could have a difference of opinion, and that's why we have courts. You might have to have a judge determine whether the conduct was wrongful. All right, but that may look like this. If I threaten, if you don't sign this contract, I'll ruin your business, right? Don't say it that way, because that's almost deemed to be wrongful. You have no legitimate interest in ruining my business. You got your business, I got mine. And if you want to do business with me, do. And if you don't. But you can't threaten to ruin my business, right? Even though it's not illegal, it's wrong. Whereas if you don't sign this contract, you buy from me, or I'm going to sell to your competitors, right? Nothing wrongful about that. That may have the effect of ruining your business. You may be scared of that. But I've got a legitimate interest in doing business, right? If you won't buy them, I'm going to sell them to somebody else. That's just a fact. So sign this contract or I'll ruin your business, maybe duress. Sign this contract or I'll sell to your competitors, probably not duress. Unless selling to your competitors would be wrongful. If there's some reason selling to your competitors would be wrongful, maybe you've already got some kind of existing contract that prohibits it. Otherwise, that wouldn't be wrongful, so it wouldn't be duress. Let me see if I can throw our PowerPoint back up on the board. We'll see if there's anything we need to finish on duress, and then we will move on to the next one. There's misrepresentation, mutual mistake, duress. All right. We were going through this list last week of things that may be duress and things that aren't. I will hurt you, duress. I'll hurt somebody else, always duress. I'll say false things about you. It's probably duress. You don't have a right to say false things about somebody. And then I was starting to mention this at the end of our last class. It's always important to check your common law. You're going to need to, duress is almost always a matter of common law. And so if you want to know exactly what you need to prove, or exactly what elements a court looks at, what is your jury charge going to look like, right? What are you asking the jury to find? You probably need to go look up your common law to see exactly what the elements are in your jurisdiction. Generally speaking, the elements of duress are a wrongful threat that subverts the innocent party's will, right? That forces them to do something they wouldn't have done, in other words. If you threaten an act that you had no legal right to do, right? Not illegal, but you had no legal right to do it, like ruining somebody's business, right? Or threatening injury without legal justification or authorization, right? Again, that's I'll threaten to ruin your business versus I'll threaten to sell to your competitor. You got every right to sell to a competitor. That's a legitimate legal, justification. But it's not right? You got no purpose in ruining somebody's business other than to force them to sign the contract. Or bad faith threatening baseless litigation, right? Even that can be duress. Let's see what I don't mean to always pick on President Trump. You can love him or hate him. It's not my job or even my intent to push my politics on you. So I'm not going to tell you whether I love him or hate him or not. But he does have a tendency to sue people. And he does have a tendency, at least there's been reports, that he threatens to sue small companies to get them to settle with him, right? To get him to get them to enter into contracts. There's been some allegations that he's had suppliers who do work for him. Maybe they're sheetrock contractors, for instance, or electricians who do work on one of his projects, and he had promised to pay them X, and he doesn't pay them. He says, well, I'm going to, you'll either agree to take less or I'm going to sue you because I'm so rich and I've got so many lawyers that'll just put you out of business, right? Even if I don't have a lawsuit, I'm just going to sue you into the ground because the legal expenses alone will drive you out of business. If you have a legitimate lawsuit, you can always threaten to sue somebody. But if it's baseless, if you're just doing it to leverage somebody, to force them into signing a contract, then that's wrongful and that can be duress. Okay, that can be duress. So check your common law to see exactly what elements or exactly the phrasing that the court gives to it. But generally, It's threatening to do something, a wrongful threat that is designed to override the will of one of the parties, right? Sign this or else. We just need to know what the or else is. Is the or else wrongful? If the or else is wrongful, then that's duress. If the or else is not wrongful, then it's not duress. It's just negotiating. Okay. It is important to understand, though, that it has to actually have an effect. If you don't believe the other side, if that's not why you signed the contract, then it's not duress. There's always some element that it had to override the party's will. It had to get them to sign something that they didn't want to sign, or something that they wouldn't have signed otherwise, in addition to that wrongful threat. Okay, so that's duress. The fifth method of invalidating, or the fifth legal theory for invalidating assent or invalidating a contract that we saw on our list at the beginning, is something called undue influence. Okay, undue influence. Now, be careful when you start talking about undue influence. Be careful when you start researching undue influence. Okay, because undue influence is a term that arises in a couple of different areas of the law. Okay, and so depending on what area of the law it arises in, the elements of undue influence may or may not be exactly the same in your jurisdiction. All right. For instance, undue influence can be sufficient to invalidate a contract in contract law. Undue influence can also be sufficient to invalidate a will in probate law. All right. In any particular jurisdiction, the elements of undue influence in contract law versus undue influence in probate law may be the same, but they're probably not identical. Okay, they may be identical. They may be the same in some jurisdictions. In most jurisdictions, they're going to be slightly different, just because of the nature of the cases, right? As case law is developed on wills that may be the subject of undue influence, they tend to veer off one way. And when you have cases that deal with contracts based on undue influence, even though sometimes those are also, the victims are elderly or people who are thinking about estate planning and that kind of stuff. But when it comes to contract law, the contracts tend to veer off and go a slightly different way. Okay, so be careful when you're researching undue influence to make sure, if you're researching undue influence for a breach of contract case, make sure you're looking at contracts cases and not probate cases. Okay, and vice versa. If it turns out they're identical, you're in your jurisdiction, great, use them both. But like I said, you don't want to be embarrassed because you showed up at court with a bunch of probate cases that define undue influence when it's a contract case, and the other side showed up with cases that are contract cases and say you're wrong. All right, so just be aware of that. All right, moving on. What is undue influence? Undue influence in contract law. Remember, we're not talking about wills and estates here. Undue influence in contract law is generally when someone with some kind of authority or control or some kind of unusual power over another person uses that power or that position of influence to improperly take advantage of the other party. Okay, usually by pushing them into an agreement. What is the exact definition? Well, check your common law, right? You're going to have to check your common law in whatever jurisdiction you're operating in to see the actual legal definition of undue influence. But generally, undue influence is about using a legally recognized position of influence over someone, right? We usually see a language like fiduciary duty. In fact, let's talk about that. Undue influence, again, it's based on some kind of special relationship with the parties, but a special relationship that the law recognizes. Okay. And sometimes we call those fiduciary relationships. What is a fiduciary relationship? A fiduciary relationship is where one party, because of a special position of confidence or trust in relation to another party, that they have a corresponding duty to act in that other party's best interest. All right. So some examples. If a patient is relying on a doctor, right, they may have a fiduciary relationship where the doctor knows, because of the doctor-patient relationship, that the patient is vulnerable and vulnerable to relying on them for things. So if you go in, you go in for your cancer treatment this week, and while you're there, your doctor says, "Hey, by the way, why don't you enter into this contract with me?" you really got to trust that guy right there, right? Why is he trying to get you to sign a contract? He's using that position. He's using the fact that you've got this special relationship and that you rely on him. If he's using that relationship to kind of muscle you into or coax you into signing something else, that may be undue influence. What about a trustee and a beneficiary? You understand what a trustee and a beneficiary is? If you put something in trust, then the trustee has full control over the trust property, but they're only supposed to use the trust property for the beneficiary's benefit. Well, that's a fiduciary relationship. That's a special relationship that the court recognizes. And so, what if your grandmother set up a trust to pay for your college, and you go to the trustee and you say, "Hey, trustee, I need a check for my tuition this semester," and the trustee says, "Well, I don't know if I'm going to sign that, but by the way, while you're thinking about it, I'd sure like to buy your car. I think I'd like to buy your car for $100, right? Well, do you think it's worth it? Gee, that sounds kind of cheap." And he says, "Oh no, I think that's what you need to do," right? Well, in that position, you're relying on this special relationship. You're depending on him for or her. And so that's a fiduciary relationship. That's a kind of special relationship that may result in undue influence if that trustee uses that relationship to try to influence you into signing a contract. Some other examples would be teacher and student, lawyer and client, guardian and ward, banker and client, maybe a financial advisor and an investor, right? A stockbroker and a customer, all those kind of things where somebody has put somebody else in a position of trust and a position of confidence. If that other person uses that position to improperly urge the other person to enter into a contract, well, then that may be the product of undue influence. All right. A common definition of influence is often something like any influence which compels a person to do that which is against his or her will from the fear, desire for peace, or some other feeling that he or she is unable to resist. I'll be honest with you, that looks more like a probate definition to me. So before I cited that one, I would want to go look up whether that comes from a probate case or a contract case. But undue influence is usually about somebody using this position of trust, right? This superior position to compel somebody to sign something that they wouldn't have otherwise signed. All right, that's an important one, that they wouldn't have otherwise signed. Common elements of undue influence are things like, first of all, the existence of that relationship. If you don't have some special relationship, then there can't be a claim of undue influence, right? If your doctor suggests that you sell him your car, then there's a doctor-patient privilege there, and maybe there is undue influence. But if I just happen to be a doctor and you just happen to be a patient, but I'm not your doctor, you're not my patient, well, then that relationship doesn't exist, right? At least not between us. So the existence of that relationship, the existence of the ability to exert that undue influence is your first element. Second element is the effect of that relationship. Did the effect of that influence overpower the other person? Did it so subvert their mind or overpower their own will that it got them to enter into an agreement that they wouldn't have otherwise entered into, right? And that's the third prong. An execution of an agreement that the aggrieved party would not have executed but for such influence. All right. May be undue influence. Does that mean that a patient can never enter into a contract with a doctor? No, doesn't mean that. Does it mean that a client can never enter into a contract with a lawyer? No, it doesn't mean that either. But it does mean that if you have that special relationship, you better do some research. You better look into it a little further and make sure that you're not improperly using that relationship to get the other side to enter into a contract that they would not have entered into otherwise. All right. So can a contract between individuals in a special relationship still be valid? Sure it can. Sure it can. But the court is going to look to protect the weaker party's interest. Okay, so typically, if you want to try to defend one of these contracts between between parties in a special relationship like this, right? If you want to defend a contract between a fiduciary and a beneficiary, then typically there's a higher burden of proof, and it's going to fall on that fiduciary. It's going to fall on that person who is in the who has that special position, right? So if a lawyer wants to enter into a contract with a client, you can do it, but the burden, but if the client has cold feet and says, "Wait a minute, this wasn't right," it's going to be up to the lawyer to prove that it was fair, right? It may, check your jurisdiction, it may be up to the lawyer to prove that he disclosed this conflict, that he disclosed this relationship to the other party before he entered into it. May also even have to show that they at least gave them an opportunity to talk to somebody else, right? So, can a lawyer enter into a contract, a contract with a client? Well, sure, you could enter into contracts like the contractor represents you. But can we enter into if I am representing you, can I enter into a contract on some kind of outside matter? Like, can we do business together? I'm representing you in a car wreck case. But hey, you want to open a McDonald's? Will I invest in it? Or I want to open a McDonald's. Will you invest in it with me? Can we do that? Sure. But I better be ready to prove that this was fair to you, right? Because I'm the lawyer. I'm the one with the special position of trust. I better be able to prepare. I better be prepared to prove that having you invest in this was a great deal, right? It was in your best interest. It was fair to you. I may need to prove that I told you. Now, you don't have to do this, but we have this conflict of interest. Be aware of that. Before you agree to invest in my McDonald's franchise, you need to at least be aware that we have this special relationship, and I don't want to take advantage of it, right? You may have to disclose that. And then third, I may even, in some jurisdictions, and depending on the relationship, I may even have to specifically give the opportunity to, hey, but before you enter into this contract, you may want to go talk to another lawyer, right? You don't have to, but at least I've got to give you the opportunity to do that. All right, so that's undue influence. But if you can prove that somebody committed undue influence, they used this special position to get the other side to sign a contract or enter into an agreement that they otherwise wouldn't have. Well, then the party can come back and claim undue influence and use that to invalidate the assent or invalidate the contract if the judge believes that there was undue influence. All right. Told you there were 6 categories for invalidating assent. The last one is the catch-all. The last one is unconscionability. Unconscionability. What does unconscionability mean? It means that if a contract is just so unreasonable, so unfair that it shocks the conscience, right? That's the cliche. That's the term of art you're going to see over and over again in these cases. For something to be unconscionable, it has to be so bad that it shocks the conscience of the judge or the jury, then it may be unconscionable, and the court may be able to throw a case out based on unconscionability. Now, normally unconscionability, again, it's that catch-all. You couldn't prove fraud. You couldn't maybe prove a misrepresentation. You tried to prove duress, but it wasn't quite there. It's just, it's still, you didn't have the elements of those other claims, but this is just so bad. It just so doesn't pass the smell test. The judge just can't bring him or herself to enforce the contract. Well, then you may be able to fall back to this catch-all of unconscionability. Say this contract is just so unfair, so unreasonable that it shocks the conscience, right? Not just kind of unfair, not just kind of bad, so unfair that the judge just can't even swallow it. The judge just can't even bring her or himself to enforcing the contract. Okay, so unconscionability could be based on something in the formation of the agreement. Remember when we're talking about fraud, we talked about fraud in the inducement or fraud in the execution. Fraud in the execution was about the contract itself, the way the contract itself was formed, whereas fraud in the inducement was about what was a lie about the consideration, right? The subject matter of the contract, misrepresenting that. Similar when we talk about unconscionability. We could have unconscionability in the procedural formation of the contract, right? Something that was, maybe you didn't lie to them about the contract. It's not fraud. You didn't say, hey, here's your lunch menu when it was really a contract. But maybe you gave them a 498-page contract. You told them they had 10 minutes to look it over, and you buried some really egregious stuff so far down in the fine print that they would never see it, right? That might be unconscionable. If one party was so unsophisticated they couldn't possibly understand the contract, right, and you just took advantage of them, that might be unconscionable, right? If you knew that the other party couldn't read, right? Either they couldn't read, maybe they were illiterate, or maybe they just didn't have the chance to read or review a contract. Again, you gave them a 497-page contract and they only had 5 minutes to consider it. Those are the kinds of things that may be unconscionable, right? That's just, it's not fraud. It's not duress. It's just, at the end of the day, this is just so unfair that a court couldn't, just couldn't bring themselves to enforce it, right? It's so egregious, so unfair that it shocks the judge's conscience. Then that fraud in the procedural formation, or not fraud, that element of the procedural formation is just so unfair, may be enough for the court to invalidate a contract based on unconscionability. It could be based on something substantive in the agreement itself, right? We haven't talked about consideration. We haven't had the chapter on consideration yet. We've talked about consideration briefly. We've talked about this idea of a peppercorn, right? That generally a court is not going to weigh consideration. They're not going to say, is the car you bought really worth $30,000? They're going to say, did you get the car you wanted? Did they get the price they wanted? Well, as long as everybody got what you contracted for, the court's not going to weigh whether it was worth it. However, if something is just so grossly unfair, right? The price is just so unfair that you really took advantage of somebody, the court just can't bring themselves to enforce it. That may rise to the level of unconscionability, okay? Or if just taken as a whole, if the contract is just so completely one-sided, so completely one-sided, it puts all the obligations on one side and all of the benefit on the other. The obligations are huge. The benefits you're getting back are just so small. If it's so grossly unfair, not just unfair, so grossly unfair that it shocks the conscience of the judge, well, then that might rise to the level of unconscionability. Okay, but it is important to understand, again, that unconscionability is extreme disparity, right? An extreme problem that is so serious that even though all the elements of a contract may be there, the judge just cannot bring her or himself into signing an order enforcing it, and so you fall back to this unconscionability catch-all. It can often be based on a party's grossly uneven bargaining power, right? Let's use old Donald Trump again, right? He's supposedly a billionaire, and he goes and hires a father and son group to hang sheetrock in one of his new buildings. And man, they don't have any bargaining power. And he just crams something down their throat. That might be unconscionability. Here's maybe a better example. I don't know if you guys remember, I haven't heard much of this story in the last couple of years, but years ago, Walmart, right? Walmart was in kind of hot water. Everybody, a bunch of their suppliers were complaining that Walmart was flat putting them out of business, right? Rubbermaid. Rubbermaid was a huge company. They sold, plastic bins and plastic stuff, right? Suppliers to Walmart were complaining that Walmart was coming to them and cramming down their throat that, you're gonna sell us your product for this price, and you're gonna sell us as many as we order, because if you don't, then we're not going to do business with you. And if you don't do business with Walmart, then your competitors are, and they're going to put you out of business. Well, it's not duress. They didn't threaten to put you out of business. But Walmart was so huge that a lot of their suppliers were complaining that they were forcing them to sign these agreements for unreasonable amounts, right? They couldn't possibly produce that much, or at unreasonable prices, right? They couldn't possibly sell it to Walmart that much, but that Walmart had so much bargaining power that they would just kind of cram these contracts down the throats of these small, mom and pop operations, or even operations as big as Rubbermaid. So if the parties if the party's bargaining power is just so grossly unfair that it leads to a contract that is so grossly unfair that it shocks the conscience, then that might be unconscionability. Okay. Now, again, it's going to take a lot. And what does it take? Not sure, because this is one of those catch-alls. This is one of those safety valves for when the judge, it met all the other elements of contract. You don't have any other defenses. You don't have any of these other 5 ways to invalidate assent, but I just can't bring myself to enforce this contract. Well, you may be able to fall back to unconscionability, but it's going to have to be extreme and it's going to have to be severe. There may be, when you see an unconscionability case, a successful unconscionability claim, they often turn on terms of public policy. There may be an applicable statute or applicable common law that forbids a certain type of conduct, right? And that would make it unconscionable. Like if we have the Deceptive Trade Practices Act here in Texas, and if the Deceptive Trade Practices Act says, hey, you can't sell stuff and exclude every single warranty, right? That's unconscionable. Or you can't sign a contract that completely gives away your right to go to court, right? You can't sign a contract that says if I breach it, there's no remedy. You can't take me to court. You can't take me to arbitration. You can't do anything, right? You have no rights. No, that's unconscionable, right? If you give away, every right to go to court, you may trade that for an arbitration clause, but that still gives you a right to some kind of redress. But a contract that says, hey, you'll never sue for damages, or hey, you can't ever go to court or go to arbitration, something like that, that may be unconscionable based on public policy concerns. There are some other types of policy concerns that come up in unconscionability sometimes, and they may not even be necessarily negative, right? There may be upsides to it. Sometimes unconscionability is just about, it's about that the courts generally are not quite ready for this yet. Let me give you an example, a personal example. Adoption, right? Adopting children. I think in general, we would all say, hey, adoption is a great thing, right? We want to support adoption. And so that's all good. But so what if you have a young woman who is pregnant and she's decided that she doesn't really think that she can raise the child? And you've got a family who desperately wants a child, right? And they say, oh my gosh, let us help you, let us support you. We'll pay your medical bills, maybe we'll bring you in your home and feed you and make sure you're healthy and clothed and sheltered, and you've got your vitamins and you've got the medical care that you need. We're going to help you get through this. And maybe on top of that, hey, maybe we pay you on top of that, and we'll also give you 10 grand, 50 grand. In exchange, you agree to let us adopt your kid, right? Sounds like a contract. You got an agreement, right? We were both agreeing on the same thing. We had that meeting of the minds. You're going to have a baby. You're going to let us adopt your baby. We're going to give you your medical bills. We're going to give you money, maybe. And then when the baby is born, it looks like a contract, right? Maybe it was witnessed. Everybody saw it. You videotaped it. It was notarized. There were 17 witnesses who signed off on the contract. But then the baby is born. And then the mother says, oh my gosh, now that I've seen it, now that I've held it, maybe I'm having second thoughts. Maybe I'm changing my mind. Are you going to enforce that contract? Maybe there's a law against it. There may be a law against selling children. So if it's a contract that I'll pay you, $100,000 if you let me adopt your baby, maybe that violates the law. So maybe that's not enforceable. But what if it's just, we were going to take you into our house and take care of you and provide you medical care, all those good things. But now the mother just doesn't want to follow through with the contract. Are the courts ready to do that? And the court may say, look, this looks like a contract. It smells like a contract. It meets all the elements of a contract. But I'm just not ready to take children away from one adult and give them to another adult based on a contract, right? I'm not ready to do it yet. That is exactly the kind of situation where courts may refuse to enforce contracts based on unconscionability, right? They just can't bring themselves to do it yet. All right. Now, if that area of law interests you, be aware that the law there is changing, that a lot of states are starting to adopt statutory schemes that provide for this kind of thing. Okay. And so it's becoming a little more normal if it goes through courts. We're starting to get a statutory basis for it and some experience with it. But 10, 20, 50 years ago, those were harder to enforce. They were harder to get a court to enforce a contract for adoption because the courts were just like, I don't know if we can do this yet. And that was the kind of thing that may fall under unconscionability, even though it wasn't something that maybe either side was bad, right? It just the court just couldn't bring themselves to do it. All right, so there's another example of unconscionability. All right, so there are in this chapter we've talked about 6 ways to invalidate a contract. Fraud requires that intent to deceive. Misrepresentation, similar to fraud, but doesn't require the intent to deceive, right? Duress, wrongfully forcing somebody to sign a contract. What else do we have? Undue influence and mutual mistake, right? Mutual mistake. So fraud, misrepresentation, duress, mutual mistake, undue influence, and then lastly, the 6th one, unconscionability. One more thing I want to talk to you about before we go. I mentioned that every chapter in this book usually has an ethics lesson of some type at the end, and we do not always go over those ethics lessons in these lectures. I encourage you to read them. They're very important, but this is a contracts class, not an ethics class, and we have a lot to cover. So we're not always going to go over them, but I think some of the ethics at the end of this chapter are important to understand. Okay, so let's talk about some of those special relationships, right? Remember when we were talking about the undue influence and fiduciary duties? Because this is an area that not only affects stockbrokers and their customers or doctors and clients, but specifically affects lawyers and clients and legal professionals and clients. And there are some specific ethical duties when it comes to that. Okay, so let's take just a couple of minutes to talk about that, and then we'll be done with this chapter. Let me see if I can share that on the screen real quick. All right, so let's talk about some of those special relationships that may give rise to undue influence, because when it's an attorney and client, it may also give rise to a lawsuit against the attorney. It may give rise even to state bar proceedings, to ethical proceedings against the attorney. Okay. In Texas, right, lawyers are governed by the Texas Disciplinary Rules of Professional Conduct. You have links to those in our course materials. You can Google it and find them yourselves. But the Texas Disciplinary Rules of Professional Conduct apply to attorneys. They do not apply to paralegals, right? Paralegals, if you are licensed, if you take the exam and you get your certificate, then you have an agency and you're required to live up to their ethics. But if you lose that certification, you could still serve as a paralegal, at least in Texas, because there's no specific law that says paralegals have to be licensed. So do paralegals need to know about the Texas Disciplinary Rules of Professional Conduct? And the answer is yes, because although they don't specifically apply to paralegals, they absolutely apply to those attorneys that you may be working under. And it's my job to supervise you. And if I do something that violates the ethical rules, I could get disbarred, lose my license. If you do something that violates those rules, that again, I could get disbarred, I could lose my license, I could get suspended. And if I lose my license or get disbarred or get suspended, then I'm out of work. And guess who's also out of work? You are too. Okay. It is important to understand that if you look at the Texas Disciplinary Rules of Professional Conduct, they specifically say that these rules are only about governing the relationship between lawyers and basically the state bar, right? That this is about conduct. It is not about creating specific legal rights. Okay, so your client cannot sue you specifically for breaching the Texas disciplinary rules of professional conduct. Only the state bar can do that, and the state bar is going to seek to punish you or discipline you if you break the rules. But that's what the rules say. But with that in mind, your client could still sue you, not specifically because you violated the Texas disciplinary rules of professional conduct, but if you've violated your fiduciary duties generally. Okay. And when the court looks at, well, what are those fiduciary rules? They may look back to those Texas disciplinary rules of professional conduct. Okay. And those Texas disciplinary rules of professional conduct, just like the ABA's model rules of ethics, they set out a bunch of rules to govern this fiduciary relationship between lawyers and clients. And they specifically have rules that are designed to avoid lawyers engaging in undue influence, right? They specifically have rules about things like entering into contracts with existing clients. And it is important to understand that they're there. It's important to understand that they generally prohibit things like undue influence and engaging in self-dealing transactions or engaging in transactions with your clients, but they don't absolutely forbid them, right? Take a look at those rules. Those rules are not just thou shalt not, right? I have known a few lawyers. We have to take an ethics exam before we can become attorneys. And I've actually seen, I had a few classmates when I was at UT who failed the ethics exam. I didn't see their grades, I didn't see their tests, but I knew some of these people, and I've known a few people who have failed it since. And it appears to me that they never fail the exam because they're not ethical enough. They fail the exam because they're too ethical. When the question says, can a lawyer enter into a contract with an existing client? Their gut reaction was to say, no, you can't do that. It's unfair to the client. And that would be a good general rule, thou shalt not. But it's important to understand, not because we're looking for ways to bend the rules, okay? But sometimes it may be in the client's best interest to enter into a contract with his lawyer, right? I mean, if you've got an existing relationship that's gone on for years, your client really trusts you. And if he was going to go into business with anyone, he would want to go into business with you. And so is it fair to say, no, I'm sorry. I know you really want to. I know that may be best, but we can't because, you know, we're lawyer and client on some other matters. See, that might be detrimental to the client. It's important to understand that those Texas rules of disciplinary conduct, or again, the ABA's model rules, they often give solutions. So can you say, no, I'm sorry, I just can't do business with you because we have this special relationship, we have this fiduciary duty and it wouldn't be ethical? Yes, you can. But you could also go, I mean, if it was important, you could also go back to those rules and dig a little bit deeper and see if there was a way to resolve that conflict, to resolve that ethical dilemma and say, okay, well, now wait a minute. Under the rules, it looks like as long as I inform my client about this potential conflict, I say, hey, look, I know you really want to go into business with me, but it may be because you're relying on me too much, right? You're trusting me because I've always been your lawyer. So you need to be aware of that conflict. Number two, I make sure that it is in their absolute best interest, right? I mean, you may think this is fair, but in this situation, I mean, as a contracting party, I have to look out not only for my best interests, but if I'm contracting with a client, I also need to make sure that it's in their best interest, right? And then lastly, I might even need to say to them, hey, I would like to do this, and I've warned you about the conflict, and I've looked at this, and I'm trying to make sure it's in your best interest, but I also want to make sure that now that you're aware of all that, you have an opportunity to go talk to another lawyer in case you want to have somebody look this over and make sure it's fair, right? And if you do all that, then you may still be able to enter into a contract with a client, for instance, even though you have that fiduciary duty and even though you're worried about that potential claim for undue influence. All right. So it's not just an issue of, well, if you enter into a contract with a client, they may be able to claim undue influence and invalidate the contract. I mean, that would suck. But it may go farther. It may be, and then they can sue you for damages for your breach of fiduciary duty, and they can report you to the state bar and maybe get you suspended or disbarred, right? We don't want any of that to happen. We want to make sure we're above board. We want to make sure we're taking care of our clients, that we're looking out for their best interests, not only because it's good business, but because it's the ethical thing to do, and we have a duty to follow those rules of ethics. And so that kind of directly meshes with that undue influence part of this invalidating assent in chapter 4. And so I think it's worth talking about and worth looking at. All right. That's it for chapter 4. Invalidating assent. We had 6 ways to do it: fraud, misrepresentation, duress, mutual mistake, undue influence, and unconscionability, the catch-all. I hope you understand those. If you don't, give me a call, shoot me an email, send me a text, come to my live class. I'm always happy to talk to you guys, whatever you need. Otherwise, read the chapter, look at your lecture notes, review the PowerPoint, and I think you'll get it. Okay. Like I said, you got any questions, give me a call. Otherwise, next week we're moving on to chapter 5, and I think we're getting to consideration, right? That's a big one. I like consideration, and it's terribly important. That's one of those major legs you have to have for a contract. So I'll see you next week. Otherwise, you got a couple assignments, get those turned in, and I'll see you next week for chapter 4. Thanks.